and social distancing. So I will turn over to Lauren Cecil, who will go through some details on the calls if you all want to ask any questions or anything. But prior to that, I do want to introduce Michael Haney. Michael is with the law firm Manier Herod here in Nashville, Tennessee. They have been a long-standing member of the Tennessee Chamber and provide a lot of guidance on some workers' compensation issues, especially those and their impacts on the employer community. So Michael has extensive knowledge about workers' comp. Whenever we have a major question, we always go to Michael, and he steers us in the right direction. So with that said, Lauren, I will kick it over to you, and thank you all for joining us today.
Hi, everyone. My name is Lauren Cecil. I have a couple of housekeeping items for you before we get it off to Michael. First, Michael's going to kind of do an overview of everything, and then once we allow him to talk, we're going to do a question portion. And so during that time, if you could either raise your hand or chat me, and we'll get your questions acknowledged to Michael, and he can answer, and then you guys can do your question and answer portion then. And without further ado, here is Michael. Michael, off to you.
All right, thank you. And thank you all for participating and attending this. I've been doing workers' comp defense for the employer community for over 20 years now. It's kind of hard to believe I'm saying that, but and honestly, right now, we've never seen anything like this with the COVID-19 pandemic, the stay-at-home orders, the impact that this has had on the business community, but also just the way it is impacting workers' compensation claims, not only existing claims, but also potential claims in the future. So what I'm going to do today is just kind of go over just a broad overview of the workers' comp law in the context of COVID-19 issues, including impact that COVID-19 and the layoffs or furloughs may have on employees' benefits going forward. I'm also going to talk about some medical issues and obviously the million-dollar question, which is COVID-19 a compensable claim? And I'll just start there. We've already had multiple calls from clients, and I'm sure you're facing issues with whether or not COVID-19 is a compensable claim. The workers' comp law defines an injury as one arising primarily out of and in the course and scope of employment, and it includes diseases, which would potentially be a COVID-19 diagnosis. But again, there are two elements that an employee must establish to have a viable claim, and that is that it has to primarily arise out of employment and the disease has to occur in the course and scope. Primarily arising out of means that the employment contributed more than 50% in causing the injury. And so we take all that and then we think, all right, well, is COVID-19 a compensable claim in light of that definition? There is some question as to COVID-19 being an act of God. An act of God is defined as an overwhelming, unpreventable force of nature. That's the way the Workers' Compensation Appeals Board has defined it. And so it would seem that COVID-19 would fit within that definition. Now, the courts have allowed compensation for injuries sustained as a result of an act of God, but it's only compensable if the employee has an increased risk of exposure to that force of nature as opposed to just the general public. And so that's kind of what we're grappling with right now is our employees who are still working at an increased risk of exposure. And we look at the definition of public, and when you consider the governor's executive orders and the stay-at-home orders requiring everyone to stay home, does that result in how does that play into the definition of the general public? Is the general public the people who are staying home, or is it does it include people performing essential business right now? I think there are a couple classes of people who may have a stronger claim or a stronger argument for a compensable claim, and those would be obviously your first line people in the hospitals, people, first responders, just people who are actually treating the people who have been tested positive for COVID-19. I think the other class of people who may have at least a strong argument would be people who have routine contact with the general public. That would include people like your cashiers. I guess that's probably the best example. Anyone else who would just have random contact with people who are not affiliated with a particular business. I think people working in a factory or just in an office setting where there's no interaction with the public, I think they would have a weaker argument. But even if you get past the increased risk or hazard argument, the other issue is the employee still has to prove that the COVID-19 diagnosis arose primarily out of employment. And that, I just don't see how an employee is going to be able to make that claim or successfully. Because it's, we don't know the transmission, and the way that this particular virus spreads, a person can get it from just about anywhere. And so to be able to prove that they contracted the disease through some exposure at work, I think would just be next to impossible. But that kind of leads to the next question. What do you do if one of your employees tests positive for COVID-19? Well, just merely testing positive for COVID is not a work-related injury. If they come, and so if you have a COVID-19 diagnosed employee, from a workers' comp standpoint, you really don't have to do anything. However, if that particular employee files a claim for workers' compensation benefits, you cannot ignore that. The Bureau's rules specifically require that an employer accept all claims filed by an employee. And that's regardless of whether or not you think it's a viable claim, or if you think for sure that they got COVID-19 from some source outside of employment. The fact that they have made a claim, you have to accept it. And when I say accept, I don't mean you have to admit compensability. You just have to receive it. You can't ignore it. But then the Bureau's regs also require that you report that claim within 1 business day. So if you have an employee who is making a specific claim for workers' comp benefits due to a COVID-19 diagnosis, you need to report that claim to your TPA or your insurer within 1 business day. And you can't sweep it under the rug by paying the employee's wages or medical benefits out of your pocket. The regs specifically provide that you cannot shift or take on the liability, thereby hiding the claim from your TPA or your insurer. You can be assessed a penalty for that, and you would also lose other certain defenses and rights under the workers' compensation law. There are a couple other types of claims that may come about. You might have a mental claim where an employee is claiming a mental injury secondary to like a fear of exposure. Generally, the courts do not find that fear of exposure to a virus or any other type of thing like that would be a compensable claim. For a mental injury to be compensable, it has to arise out of a sudden stressful event that was unexpected, and sort of, I think the best example would be like a robbery or something along those lines. So generally, a mental claim out of fear of exposure should not be compensable. There's also an issue of whether or not a quarantined employee would be entitled to workers' compensation benefits. I believe it's I think New Jersey has released information suggesting that they would accept that employees who are quarantined due to a COVID-19 exposure could be entitled to workers' comp benefits. That's not the case in Tennessee. I haven't seen anything along those lines. And just quarantining itself is not an injury. There has to be an actual contraction of the disease, as I discussed before. One of the other issues that we're encountering right now is issues with temporary disability benefits, especially with workforce reduction that is taking place either through furloughs, layoffs, and I think I've heard of a few employers offering buyout packages. So I'm going to kind of touch or kind of go over what the temporary disability benefits are and how furloughs and layoffs, buyouts can impact those. There are two different types of temporary disability benefits. There's temporary total disability, and then there's temporary partial disability benefits. Temporary total is when the employee is completely taken off work by the authorized treating physician, or if the employee has light duty restrictions that the employer is unable to accommodate. An employee is entitled to temporary partial disability, excuse me, if the employee has light duty restrictions and comes back to work but is earning a wage that is less than the employee's average weekly wage. A good example would be if the employee's average weekly wage at the time of the injury was $500, the employee comes back to work on light duty, is only able to make $400, the employee would be entitled to a temporary partial disability benefit, which would be 66 2/3% of the difference between the average weekly wage and the wage the employee is able to earn. So it'd be 66 2/3% of $100. There are also some issues when the employee is on light duty, but then doesn't come back to work for one reason or another. A good example would be, the employee has light duty restrictions, the employer offers a job, the employee goes and works for the employer for a period of time, but due to pain or some other limitation due to the injury, the employee is not able to resume employment. In that particular scenario, an employee would be eligible for temporary total disability benefits. But then there's another issue where maybe the employee just has a personal reason that they're not coming back to work. And in those situations, the courts usually apply what's called a reasonableness test. The court will analyze the reasonableness of the employer in trying to return the injured worker to work, the reasonableness of the work being offered, with the reasonableness of the employee's refusal to come back to work. So, for example, if just the employee doesn't want to work the second shift, that would not be a reasonable excuse. And in that type of scenario, the employer or the employee would not be eligible for temporary disability benefits. A couple other issues that we're seeing with regards to temporary disability benefits, an employer can continue to pay wages in lieu of paying temporary total disability benefits. The only limitation is the employees, the wages cannot be less than what the employee would otherwise receive in temporary total disability. And so if there is let's say, for example, the employee's temporary total disability benefit is $400, you're paying the wage of $300, the employee would still be entitled to $100 in temporary total disability because the wages cannot take the employee below what they would receive for TTD benefits. So how is all this kind of factored into different questions that we've been receiving at the firm? Let's say that you have someone who's off work completely. They're receiving temporary total disability benefits, and then you have shut down your plant or just laid off just about everyone because of COVID-19. The question is that employee still entitled to TTD benefits? And the answer is yes. And I understand the argument that it doesn't seem fair because everyone else is getting laid off too. But the way the courts see it is that particular employee with restrictions is unable to find alternate work, or most likely is unable to apply for unemployment because they can't certify that they're ready and able to work. And that does bring up an issue with unemployment benefits. If you have an employee who applies for unemployment benefits. They've been laid off. They're applying for unemployment, but they're also receiving temporary disability benefits. Does the employer get a credit? The answer is no. But the employee cannot double dip. So the employee will still be eligible for the temporary disability benefits, but the employee then has to repay the unemployment compensation back to the state. Other issues, if the employee is, let's say you have an employee who's working light duty, you've made a job available for them, they're working at the plant, and then you lay everyone off. In that scenario, that particular employee would probably be entitled to temporary total disability benefits, just like the other example. But if that employee does find alternate work, then with another employer, then you would only owe temporary partial disability benefits. I'm receiving a lot of questions where employers are trying to get employees injured workers to work at home, working remotely while on light duty restrictions, and that's perfectly acceptable. And if the employee is able to do that work, then you can avoid a temporary disability benefit claim, or at worst, pay a temporary partial disability claim. But you have to also consider the reasonableness test. And a good example would be you have an employee who you're going to provide light duty work at home, but it requires a computer and an internet connection. Let's assume that the employee does not have a computer. And that's why the employee is unable to do the job. In that instance, the courts would most likely find that the employee is entitled to temporary total disability benefits, just in the fact that, is it reasonable for the employer to expect the employee to go out and buy a computer in order to work from home? But on the other end, if the employee is unable to perform the light duty work for family reasons, childcare issues, that sort of thing, I think the employer would have a stronger argument that no temporary disability benefits are owed in that situation. In the area of buyouts, receiving some questions regarding where employers are offering buyouts to certain employees. And some of these buyout packages include a continuation of compensation after the period of employment has ended. In those situations, let's kind of run through the different scenarios. If you have an employee who is currently completely off work, and that employee receives or opts into the buyout program and is receiving wages because of that, I think the employer would have an argument that the wages per the buyout package are wages that and you can reduce your TTD payment by whatever wages are paid. I think the same scenario would apply for the employee who's receiving a temporary partial disability benefit. You basically would just take the difference between what the employee's average weekly wage and whatever wage you're paying as part of the buyout program, and then the employee gets 66 2/3% of that. But the other situation where the employee may not be eligible for anything is if you have an employee who is working light duty and is able to do it, and you're paying temporary partial disability benefits, and then you offer the buyout package, and the employer is would still be able to accommodate the employee's light duty restrictions had the employee not opted into the buyout program. In that particular situation, the employee would not be eligible for temporary total or temporary partial disability benefits. And the reason for that is the employee demonstrated an ability to do the job. The employer was planning on continuing that position, was not going to eliminate it as part of the buyout program. And so, it was up to the employee for personal reasons, that being just the decision to take the buyout program is the reason why the employee is no longer working. And so I think in that scenario, the employer would not have to pay any temporary disability benefits. Now, I did touch on having employees working light duty from home. Telecommuting obviously is very popular right now. And several years ago, the chamber was actually involved in a case, and I was in the Tennessee Supreme Court. It was the Wait versus Travelers case. And I worked on the amicus brief on that. And that was the first telecommuter case in Tennessee. And it was decided under the old law, which has the more liberal pro-employee standard, but I think we can pull some of the holding and apply it to a new law claim if you have an employee who's working remotely and is injured at home. What the court said in the Wake case was that an employee working at home and is injured while working at home is in the course and scope of employment. In the Wake case, the employee was injured when she was attacked by a neighbor while in her preparing lunch in her kitchen, and the court found that she was in the course and scope of her employment while preparing lunch in her kitchen. And the reason being that the employers typically provide kitchens and break rooms on the premises, and so the employee's kitchen was similar to that. Ultimately, the court found that the employee was not entitled to benefits because the attack itself did not arise out of employment. But there was some other language in that opinion that you need to be mindful of, and that is that the court, in looking at the course and scope element of the injury, noted that the employer did not have any parameters on when or where the employee worked in the home. In fact, the employer in the Wake case was aware of the work environment because they had had meetings in the house, so they knew where she was working. They knew about the kitchen, but the Supreme Court said that despite having that knowledge, the employer did not dictate when or where the work was to be done, and that the employee was not doing any prohibited conduct at the time that the injury occurred. So if you want to try and limit your exposure for these employees working at home, it would be a good idea to put some parameters on when and where the particular work is done. While the Supreme Court did not come right out and say that's what employers need to do, I think just the holding and the reasoning in that in the opinion, I think the court would be open to an argument that an employee was outside the course and scope if you have certain limits. You can set limits by time, and you can set limits by space or workplace. I'm aware of certain employees who might work from 7 a.m. and just work a couple hours, and then work a couple hours in the afternoon, and then work up until 9 o'clock at night. Potentially then that employee is in course and scope of employment from 7 a.m. until 9 p.m. at night. Now, I know that employees have other demands on them right now with kids at home and everything, but just know that if you're not putting any kind of constraints on when the work is performed, you do run the risk of a work comp claim when the employee was cooking dinner. So just be mindful of that. The other issue that we're seeing is we're seeing some issues regarding medical treatment and new claims. A lot of doctors are not seeing patients right now. I have several claims where we're having a hard time putting together a panel of physicians because employers are not accepting new patients, or doctors are not accepting new patients, or they are holding off on setting appointments for several weeks out. Keep in mind that we still have an obligation to provide and employ a panel of physicians whenever an injury occurs. And according to the Bureau's regulations, the panel must consist of 3 doctors who are willing and able to treat the employee timely. And that's timely is, I think, the big problem we're having right now is, some of these doctors aren't seeing them for 30 days out. So does that meet the criteria for timely? I would argue that right now it would. I think it's a relative term And if all the doctors are treating it the same way, I think it's safe to keep putting those doctors on your panels. One way to work around that is to just provide a panel of walk-in clinics, urgent care centers, and then just get your orthopedic through a direct referral. The board or the appeals board has approved that. Just know that if there is a direct referral, the ortho will not be, their opinions will not be presumed correct. You lose the presumption of correctness that's afforded to a doctor when it's done, when the employee is directed to that particular doctor through a direct referral. We're also having trouble getting employees to maximum medical improvement, again, just because of the delays in treatment and getting these employees back in. I had a call just this morning where the employee was supposed to see the doctor last week. We're hoping for an MMI, and that appointment was canceled because the doctor's no longer, or temporarily not seeing any patients. So are those employees still entitled to temporary total disability benefits? Yes. We're the same with a temporary partial disability, because the temporary disability benefits end only when the employee either returns to work or reaches maximum medical improvement. One avenue that you can explore is whether or not the physician has stopped all active treatment and is really only treating the employee for pain. If that's the situation, then you can statutorily terminate TTD benefits. The statute provides that when the physician is only has ended all active treatment, is only treating pain, the employee is presumed to be at maximum medical improvement. There's also seeing some situations where the employee is non-compliant with treatment. When an employee is non-compliant with medical treatment, the employee's entitlement to benefits is temporarily suspended. So if you have someone who's on temporary total disability benefits and they're non-compliant with medical treatment, you can terminate their TTD benefits. Some of the issues we're seeing right now involve employees who might be claiming that they're sick or have COVID or are just afraid of contracting COVID and are trying to comply with stay-at-home orders. If an employee is sick or is self-quarantining due to illness or potential exposure, I don't think you will be able to terminate TTD benefits in that particular scenario. If the employee just merely has a subjective fear of contracting COVID-19 by being out in public, I think you have an argument that the employee is non-compliant and you can terminate TTD benefits. One thing that you can try and do in that scenario, if you have an employee who's avoiding going back to the doctor due to self-quarantining or just out of a fear of contracting COVID-19, is you could do some social media surveillance or actual surveillance and just see if the employee is actually still leaving the house. If the employee is still leaving the house, going into other business establishments, I think then you've got a really strong argument that the employee's eligibility or right to TTD benefits should be suspended due to medical noncompliance. So those are the big issues that we're seeing right now in workers' comp. So I guess we could open up to some questions.
Yes, thank you, Michael. And sorry, I should have explained better at the beginning. If you have a question, which we've gotten some already, and I can read out loud to Michael, please feel free to chat, or at the bottom, if you see manage participants, it should open a little pane window. You can do raise your hand and we can unmute you so you guys can talk back and forth. But with that, I will read this first one from C. Mead. He asks, or she asks, sorry. So we need to be more specific to the area of the house they are in, i.e. personal office.
Yes, that would be one way that you could control or limit your exposure. If you have the employee work in a designated space, that limit, the work is to be conducted in that space. And beyond that, you can also, dictate, when the employee should be in that space working. Like I said, if you have someone who's just, plopping down on the couch and then working at the kitchen table and then working in the dining room and then working in the bedroom, I think that expands potentially the scope of, the course and scope of employment. And you run an increased risk, if the employee's, flopped on the couch and then gets up from the couch and trips over the coffee table, that's a compensable claim.
Great. The next question we got is from admin. If employers use a staffing company, can an employer still qualify for PPP, I think the payment protection, PPP, because when we do open, we still have to pay them without receiving any benefits.
So I'm trying to get clarification on that. So it's an employee who's receiving wages through a
If an
staffing
employer
agency?
uses a staffing company, can employers still qualify for PPP?
I'm not really sure about that one.
Okay.
So I'm not sure if they're asking. I mean, there are permanent partial disability benefits, and that's something I meant to touch on. I can come back and talk about that in a few minutes. Temporary, I mean, if you have an employee who's receiving temporary total disability benefits, but they're also receiving a wage of some kind, whether it be from the employer or from the staffing company, that the employee's TTD check should be reduced by whatever is being paid. Hopefully I've answered that answers the question on that.
We can look into that and
Okay.
try to get back to that person. The next question we have is from Angie. How should we handle an hourly employee who refuses to come to work out of fear of catching the virus? He or she is not sick, nor is anyone else in the workforce.
In that particular scenario, I think that kind of wraps into the TTD or the when I was talking about non-compliance. If you have an employee who's on light duty and they're refusing to come to work because of out of fear of COVID-19, I think you have an argument that they are not eligible for permanent disability, temporary disability benefits.
Okay. The next one is from Cole. If you have employees who got into another employee's workspace to clean after positive, is that considered an increased risk because that would be out of the scope of their job?
So if I understand the question, the employee is going into an area of the business where someone had tested positive, was working. And does that pose an increased risk or hazard? Probably, I would say that employee would have an argument that they are at an increased risk, even though it's beyond their job description. It's still in the course and scope of employment. I think that would put the employee in a situation similar to maybe a cashier or medical personnel who are actually treating. Some of our clients, provide food service in the hospitals, and they're going in and out of the hospital rooms, and so you do have a question as to whether or not they have an increased risk of exposure because of their employment. So I think if you have someone who's going into a known area like that I think that employee would have a stronger argument. But again, if the employee doing the cleanup job tests positive, they would still have to prove that they contracted it in that workspace, which I think would just be next to impossible.
All right, well, I don't see any more questions in the chat. If you have a follow-up question, you can email info@tnchamber.com. Oh wait, another one just came in.
And I can hit on permanent disability benefits too real quick.
Oh, sure.
I kind of glossed over that. You want me to go ahead and do that part now?
Sure.
Okay, so when I was talking about temporary disability benefits, we also are seeing potentially some issues with regards to permanent disability benefits. And permanent disability benefits are what the employee receives after reaching maximum medical improvement. There are two types of permanent disability benefits, or two levels. There's the initial benefit, and then there's increased benefits. The initial benefit is what every employee gets as long as they have an impairment rating, which is 1 times the impairment rating. Now, if the employee does not go back to work for the pre-injury employer or any employer by the time that the initial compensation period ends, then that employee would be eligible for increased benefits. And the fact that would involve the factors, a minimum of 1.35 factor. But there's going to be if the employee is on furlough or layoff when the initial compensation period ends and isn't working anywhere else, that employee might be eligible for increased benefits. And that's where I think the difference between furlough and a layoff is important. If the employee is merely furloughed with the understanding that the employee will be coming back to work, I think there's a strong argument that the employee would not be eligible for increased benefits. And that's based on some Tennessee Supreme Court case law under the old law, but I think it would apply under the new law as well, where what the courts look at is whether or not there's been a permanent termination of the employment. In situations where the employee might be on a temporary layoff, where they're retooling the plant or things like that, the courts will generally hold that that is not a terminable event where that would trigger an employee's right to increase benefits. If you are involved in a layoff, however, that is different in that the employee has no expectation of going back to work for the pre-injury employer. And so in that instance, the employee has a pretty strong argument that they're entitled to increased benefits. But one thing to keep in mind, this was added in the workers' comp statute after the last big economic crisis. Increased benefit, an employee is not entitled to increased benefits if the employee remains employed and is receiving a reduction in pay or hours that affects at least 50% of all hourly employees at the same location. So if that's the situation, then statutorily the employee is not eligible for increased benefits. So those are some of the issues with permanent disability that we're seeing.
Thank you, Michael. Okay, we got a couple more questions in. And if we don't get to your question, we'll definitely do our best to try to answer that offline. And then one correction, I accidentally gave you the wrong email. If you have any questions after this, it's info@tnchamber.org. I apologize about that. Okay, next question is from Eddie Rogers. Can Michael review the instructions in regards to an existing claim trying to reach MMI?
Could you repeat that one?
Sure. Can you review the instructions in regards to an existing claim trying to reach MMI?
Okay, in other words, just kind of cover what I had said before, I guess.
I believe so.
Yeah, all right. So just to kind of get the overview, again, if you're paying an employee temporary disability benefits, or the employee remains eligible for those benefits until the employee reaches maximum medical improvement. Some of the issues that we're having with MMI is the doctors are not seeing patients, or it's taking longer to get employees to MMI because they need to have surgery, but they're not doing the surgery. So unfortunately, we're kind of stuck in that scenario where you're going to have to continue paying TTD benefits, even though the course of medical treatment is protracted due to the COVID-19. Then I also kind of touched on non-compliance. You can, if you have an employee who is not going to the medical appointments that you've scheduled because out of fear of contracting COVID-19 or because the employee is sick and or self-quarantining due to exposure. Just to kind of run down those scenarios. If the employee is actually sick or is self-quarantining due to exposure to COVID-19, in that situation, the employee would I don't think you can terminate the temporary disability benefits due to non-compliance. If the employee just has a subjective fear of contracting COVID-19, I think you have a strong argument that the employee is non-compliant and you can terminate TTD or temporary disability benefits in that scenario. And again, if you have an employee that who's claiming to be sick or has a fear of going out or says they're self-quarantining, you can do social media search or surveillance or actual surveillance and just see if the employee is active outside the home. One other thing, just to back up real quick on getting the employee to maximum medical improvement. One avenue again is you can try and get the doctor to state that the doctor has concluded all active treatment and the only ongoing treatment is for pain only. In other words, the doctor is not prescribing physical therapy or does not have a surgery in the future. In that particular scenario, under the statute, the employee is deemed to be at maximum medical improvement, statutorily presumed. So you can cut TTD off at that point.
Great, thank you. Another question from Ashley Gold. Michael, would you agree that workers' compensation only applies to those who have an injury arising out of and in the course of employment? So a healthy employee who is sent home due to a required quarantine, that is not a work comp claim.
That's correct. To be eligible for workers' compensation benefits, you have to have an injury, which is an injury that arises primarily out of in the course and scope of employment. It does include diseases, but if you just have someone who's sent home for self-quarantining, that in itself is not an injury. Again, like I said, I think it's in New Jersey, it's taken the position that may be a compensable claim, but under the Tennessee statute, it is not.
Great. So I don't know if you touched on this a little bit, but I was going to ask, what is the future of workers' comp because of COVID-19 looks like? If you could.
Yeah, I think, what we're going to, being that this is the first major pandemic, the Workers' Comp Act was enacted in 1919, which was right, the year after the Spanish flu broke out. And since then, we really don't have much guidance in the way of case law, and the regs don't address situations like this. But I think going forward, obviously we're going to see some new case law come out of this. Probably have a COVID-19 claim, and all the other issues I talked about. And I think also, the Bureau is taking steps right now to kind of ease some of the requirements. For example, case managers no longer have to have the face-to-face contact with the employee. So I think that the Bureau will find ways to pivot and to kind of loosen the rules a little bit to enable us to adopt or adapt to some of the issues we're having. I talked earlier about the panel requirement, and if you don't provide a panel, or if you provide a bad panel, you could be subject to a penalty. But I would think that, considering everything that's going on right now, that the Bureau probably wouldn't impose a penalty if one of the doctors on your panel couldn't see someone for 45 days.
Great, good deal. Well, thank you, Michael. This is all really good stuff. Well, I just got another question via text. Let me read it off. And this can be our last question. how much flexibility is there within Tennessee state law for new pandemic related rules to be promulgated? It's hard for me to say.
Yeah, well, unfortunately, promulgating rules is kind of a drawn out process for the Bureau, because those, they draft the rules and then they have to be approved by the Attorney General has to review them and approve them before they can actually be published and enacted. So, it's kind of a slow process. We could see coming out of this maybe a set of rules or ways where and I'm just not familiar enough with the administrative aspects of it, but perhaps the administration or the Bureau would have a mechanism where they could temporarily suspend the rules. But obviously, the workers' comp law gives them the authority to enact the rules, and so I think they could probably. I think it'd probably be easier just to suspend some rules as opposed to creating a whole new set of rules.
Well, good. Well, thank you again. Again, if you all have questions, feel free to email us at info@tnchamber.org, and we will get back to you. Thank you, Michael, for taking the time out of your day to do this. We appreciate you, and
Glad to be here.
hope you have everyone stay safe and have a good rest of your day.
Thanks.